chapter 11. We ready for chapter 12 then?
Chapter 12 is the subdivision regulations. This is where all everything having to do with changing your property has been placed into. The first actual highlighted change I have is not until page 190, and it's regarding no WTS, but there was some discussion earlier about the preliminary plat review, which is section 3E.
Before we get on there, could we double check scope of regulations here? Regulations number C. Okay. I just had it, I just wanted to. Okay, the stuff about 35 acres had been taken out. Okay. That was the one that I had, that was the one that I had marked up here, so.
C2?
C4. Requiring, is that the one, that was the one requiring
Endangered species and
street, no, that was the one requiring a street plan.
Yeah, that was actually the planning commission recommended pulling that out. We put it into chapter 4 with other traffic components.
Well, we didn't leave the 35 acre point in there, did we?
It is probably worth going back and looking at to make sure. Street plans, it's on page 83. So it's chapter 4, section 2C. 2, under access generally, E is street plans. And the reworking of this language was intended that if somebody's doing a 35+ acre subdivision and they want the roads to be dedicated to the public, then this would apply. Where they have access connecting to the public right-of-way county road, this would apply. Otherwise, if they're just creating roads within their subdivision, this doesn't apply. And this was a rework from the resolution that was previously attached as an appendix to 2021. We tried to make it have more clarity as far as what that was intended to be. Because there is statute relative to this as well.
Any questions or thoughts on that?
Okay, I'm gonna have to go back and review a little bit because I had it in chapter 12.
Yes, it was taken out of chapter 12. Because it's more about access and public right-of-way than it is subdivision.
But a lot of chapter 12, particularly the beginning, is where we were working with the county surveyor community. Trying to make that more efficient and simple for boundary surveys, boundary line adjustments, and boundary agreements, correct?
And clarify terminology and process around those, yes. And so while a boundary line adjustment is not a subdivision, it's in here because it is adjusting the parcel description. But it also goes on to create distinction in section 2 between a minor plat and a boundary line adjustment. In addition, we also adjusted the checklists that go with the application that addressed a lot of what the surveyors were asking that weren't necessarily regulatory in nature, but more of, again, procedural, what's needed in a boundary line adjustment. We have a separate checklist for that, for a boundary line adjustment and a replat, versus a preliminary plat and a minor plat, which are subdivisions.
Which will make both landowners and surveyors happy.
We'll see.
Yeah. Mike, any notes you have on chapter 12 you want to bring forward?
I just see the page 190 OWTS on the soil in that area. Can you address that?
And as I mentioned, I don't know if your board wants to have further discussion about the preliminary plat review process. The way it is written here is the planning commission would be a decision-making body on the preliminary plat. The final plat still comes to your board for acceptance. And as I mentioned, I looked through statute, I didn't see anything that would prevent that. But it's up to you how you want that.
Well, I'm torn both sides of this because I want to streamline the process for the applicant, and that was the general intention here. But I also, I feel sometimes, no offense, TK, but the planning commission gets really carried away with some of the restrictions and requirements. So I get leery of, because by the time it comes in as a final, it's pretty much past the point of fixing some of those unneeded requirements that are placed on an applicant.
So the applicant would still have the ability to appeal the planning commission decision to the board.
Well, and that's the challenge. I mean, most of the time, the applicants, once they've been through this process to this point, they're just trying to get it done. They're willing to take their whoopings just to try to get the project finished. And that seems to be the case, is, that there's conditions put on that plat that are a little bit outrageous, and they are just willing to go along with it because they don't want to start the process over going through the variance. And that was my thought with keeping that to the commissioners, so there would be a chance to maybe act like the saucer on the teacup a little bit.
So let me ask a question. If you bring in a preliminary plat to the planning commission, it's not the same as a development hearing, or is it a public hearing?
Yes.
Is it about the development, or is it about the plat? I mean,
Yes.
Well,
The plat is development.
well, we haven't, will we have heard a presentation on the entire development? I mean, I guess I'm wondering if it was just.
If we know about it. Like, for example, we had one out of off Highway 133. It was a preliminary plat. It also included a rezone. So with the rezone, it would be going to the planning commission with a recommendation to the board for that anyway. But say it didn't. They had plans for what they wanted to do with the lots that they were creating. They were creating commercial lots, and they had a kind of a master plan for that. Yes, at that point, we would share that, because that's information we have. But if they just want to create lots and we don't necessarily know what their intent is,
Yeah, and the planning commission can condition the preliminary plat?
yes,
Okay.
it's a discretionary action.
Okay. I understand the concern. I guess I was thinking if we get just a preliminary plat to us, it's not often that we're gonna scrutinize it like a hearing, and review the entire development, because it's gone to the point of preliminary plat. Normally, we would have heard a public hearing before it goes to preliminary plat, but you're saying that comes up right at the beginning now. They're doing preliminary plats up front.
Right, and like we had the one out of Bull Mesa Road that was a preliminary plat, it was already developed. They were just dividing it up for the family.
Yeah, did we even condition it?
That one was conditioned because from the clustered subdivision perspective, the stewardship area. But there weren't a lot of conditions
I
there.
don't know about
And once again, I'm not saying that this is something that happens all the time. There's plenty of times that we reach a point of, and I asked the applicant in public meeting, are you aware of this condition? Are you comfortable with this condition? Because, and most of the time they say, yeah. Sometimes it's a reluctant, well, yeah. But that's the.
Well, the intent is, if we condition it, and they don't want it, we want them to come to you. So because you're the final thing, then that's exactly what it is. That's what the process is, and we don't want to be the final arbiter on a plot.
But in defense of a preliminary plat in front of the PC is, it speeds up the process too.
Well,
It give-
once again, that's that dual-edged sword, you
Yeah.
know, of.
If it gives them that coarse filter, we forgot all about that, let's get it in there.
The flip side of that is that if the board doesn't see it until final, there may be something that the board says, wait a minute, no. And the applicant, the developer, has already spent a lot of money and a lot of time and it's way down the process before this board sees it at all. So it's also that balance between relying upon your experts on the planning commission and wanting to see it yourself just to get that first initial. So, I mean, that's what you're debating. That's the balance.
Yes, it is.
Yeah. However way you'd like to go, if you want, we can change the what planning commission recommends to the board and just expand the process for that.
But again, have we ever had a preliminary plat with conditions of approval that this board rejected?
We've had stuff that we've had to send back. But we've done it in the,
Under the new land use code?
not under the new
No.
land use code.
Right.
But like I said, by the time the final plat gets, it's such a, you know, it's not the full report, it's pretty much a watered down staff report and we don't ever see it.
That's why we have 9 sets of eyes looking on a plat.
But if we condition a preliminary plat, they can still bring the preliminary plat to you guys as an appeal, like, hey, I didn't like this condition, correct, before they go to a final plat. That's what I'm trying to look at
Or
with
the
John, so
board
that.
adjustments, correct?
No,
it
would go to you, not for the planning commission.
That's right, it would go to you, so I want them to retain that ability, that if planning commission puts some onerous thing in, you know, that they have that ability to change it before they go to a final plat with your say. And I don't see any reason why they can't do that, unless you want to automatically go from us to you, you know, that's really the only change.
So again, the applicants need to know they have that ability.
That's right.
That would be the follow-up of action.
I'm still struggling with this one a little bit. I'm not sure what the best path is forward. I'm giving it a lot of thought and I'm still, you know, I'm still torn a bit on that one, so. But I also, John brings up a good point. The other part of that is, you know, this board meets regularly enough that we could feasibly, pretty much within 2 weeks, have that in front of us most of the time.
It's effectively the same report that went to the planning
Right.
commission, just adding what the planning commission's
Right.
discussion and action was.
Right.
But maybe it ties into what you're saying,
The notification is 2 weeks in and of itself, though.
Right.
and we better educate the applicants on their ability to appeal. Meaning, like, hey, if you didn't like this, here's a handbook, you can take it to the next level, just so they understand that before they spend more money for final plats and things like that, if that helps make it comfortable to you.
Well, and from the timeline perspective, like I said, it's minimum 14-day notice. So effectively, it's a 1-month timeframe.
Mike, where are you at on this one?
Still thinking about it. Not really ready to give my opinion on it yet.
Okay, fair enough. Again, this would be a good one to hear from our citizens on.
Okay. Like,
Which page are you on?
183. Subsection E. There. Actually, go down and highlight E and F. E, 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 E.
E2E.
E.T. The only other change I had in chapter 12 was subject to OWTS. So if there's anything else.
So, Carl, when you and I met, we talked about, because, you know, basically, chapter 12 is a conglomeration other parts of the code.
Correct.
And I'd talked to you about possibly, you know, a quasi red line version of, you know, whereabouts exactly this came from the code and what changes were made in this section, chapter 12. Have we gotten any closer on something like that, or?
I did a matrix that showed.
I seen kind of a summary, but still, there's a lot of stuff that got totally reworded into chapter 12
Right.
from prior chapters.
And rather than having, you know, the administrative process over and over for each section, it's all now here in one place. So no, I have not gotten it to a very specific red line
Because
beyond that summary of
okay.
identifying
That's
what
been-
changed to where it came from.
That's been one of my challenges in this chapter, because as I've gone through, I find something, I'm like, okay, this was pulled out, put in chapter 12, then I go to chapter 12 and
It's different.
kind of having trouble finding it because it's not really there. It's been reworded and rechanged, and I just, I get concerned that, you know, we're technically got a whole new subdivision regulation chapter here, which we do, but, you know, I know we also, we spent a lot of hours in community meetings in 2018, 2019, and 2020 trying to develop this code as it was, so.
And the planning commission had one specific, or two actually, meetings with the surveyors specifically.
Well, I know we had 3 or 4 meetings with surveyors in here trying to make sure everything was changed the way it needed to be to meet statute, and I think we've done a pretty good job of that. I'm just, like I said, I'm just curious if you'd had any better luck with that, because
I haven't figured out how to do that easily.
it's been a challenge.
That's why I started with a summary, so I could
Right.
figure what came and went from where, it was kind of that crosswalk of where it came from, what changed in that, and where it went to. If you'd like, I could still
Well,
put
I'm just,
effort into doing that,
no, it's just, I didn't know if you'd had.
not beyond that summary.
You know, what would be worthwhile is to get chapter 12 to Chuck Dubs as an incoming county surveyor.
Okay.
And get a fresh set of eyes on it.
We do that. Yeah, he wasn't part of the other conversation, so.
Let's do that, see if he picks up anything we're missing.
Okay.
And ask him specifically about preliminary plats.
Okay.
Right.
Chuck Dobbs is the new surveyor.
Dubs?
Dubs?
Yep.
I just remember seeing Ken Schaff's name.
That was an
Interim?
incorrect report from the newspaper. We don't know how it happened.
Oh, okay. Thanks.
Ken Schaff is still interim though, right?
Yeah, he serves an interim, and I'm sure he'll still, Chuck's unable to do conflict, or he's out of town, and Ken still have to do that. As a contractor, I guess, would be the best way to put it.
Chapter 12, anything else we want to direct?
Like I said, I've spent a lot of time on this, just trying to hash it all out, make sure it makes sense of it, make sure we're not missing anything, or make sure that we conveyed everything from what was previous to now, so it just,
Well-
take a little more time to delve through it all.
And in the summaries, just to highlight, there is more to it. We added the signature blocks, plat notes, which were not in 2021. They were in the previous regulations. We went through and updated language to kind of tie in with the land use code. So the whole latter part of this, and as well as the ability to phase a plat, vacate a plat, vacate a right of way, was all brought forward from the previous subdivision regulations and then adjusted for current conditions.
Is that 12 is where you consolidated all the issues for subdivisions, right?
That's correct.
Right, that was, because before there were You couldn't go in, it would say, you know, you'd have to go through a million pages, and I think, so when you take, you couldn't just cut and paste and put it into one section.
Oh, and that was one of the tasks that we had put forward to Carl and you guys when we had that meeting, was we were trying to find some way to consolidate it, make it easier, because from the 2021 code, that was a mistake, that we didn't make that easier. And that was our intention of that task. It's just, it's all in one location. I'm just not sure it's easier.
There's a lot of issues with subdividing.
Oh, no, absolutely.
Into one place, it makes it look like a big chapter on itself, but at least somebody can say, all right, it's all in one place. Yeah. I don't know if you
And it
do-
standardizes a lot of the plats so that you know where to look.
Yeah, that was the intent, is somebody said, what do I do about subdivision? You go to chapter 12. Instead of good luck with the whole code, you know, trying to make it easier.
And once again, that was one of the things that we were looking for. I'm just, like I said, I'm still trying to.
But let the surveyors, I mean, they're the ones that had a lot of input on how it was working, and another set of eyes from a surveyor would be helpful. Because we did hear a lot of written comments from the surveyors, sitting down, meeting them for hours. And I think that's all incorporated into 12. And they'll use it, and if they don't like it, we'll hear from them again.
No doubt.
No doubt. Which is how it works.
Anything else for chapter 12, commissioners? We're about ready to put Mr. Bear on the spot here.
I'm always on.
Lucky number 13.
Can we remember that? Chapter 10 was just reserved. Let's put it at 10.
So we're at chapter 13. Mr. Bear is going to pick up on enforcement and remedies.
What would you like me to address?
What's changed? What would you like to bring to our attention?
So 13 was basically almost a complete rewrite. And the reason being that in the 2021 land use code, chapter 13 effectively just referred to the statute. And that's really all it did. So chapter 13 now, I think, gives some more detail about the enforcement mechanisms within statute, both within the zoning resolutions, the statutes referencing the zoning resolutions 3028, 124, 124.5, as well as the subdivision regulations, 3028, 110, 133, 137, those kind of work together in the subdivision world. It kind of breaks out some different categories of enforcement. And so I'm on page 195 under remedies. B1 is the option of criminal prosecution. Of course, that is under a very limited set of factual circumstances on a subdivision situation. Any kind of injunction or that sort of thing, which would likely be a district court action to stop some sort of an action. County court actions for civil remedies. And I'm going to talk about the first three there, kind of as a whole. It needs to be real clear that that those three options can only, the way it's written, can only be initiated by the Board of County Commissioners. So before any of those actions would be taken, that would be presented to the board, and the board would say, yes, go forward, or no, don't go forward. The fourth option is what we have talked about a number of times in different forums and that sort of thing, is the civil infraction. Now remember, an infraction is, it is a civil, it's not a criminal process, it's a civil process. I've referred to it before as kind of akin to receiving a little speeding ticket or something. It's not a criminal, it looks, from a procedural standpoint, it might proceed and look like a criminal process, but it's a civil infraction, it's civil. And this code, the way it's written now, allows the code enforcement compliance officer to issue those, that sort of thing. So, there's also administrative remedies. Administrative remedies are things like, you know, other rights, right to work in the public right of way, access permits, address permits, OWTS permits, and that sort of thing. Obviously, the county can withhold those if somebody is out of compliance. So maybe I'll pause there and see if there's any questions.
Let's go to the non-liability section here.
Okay.
That's been brought up, yeah.
And I can completely understand the last sentence of that. The first part seems like we may be pushing the edge a little hard. Because the police have to be policed also, shall we say.
Okay. Really, I think that's just a statement that the county's not waiving any inherent or statutory rights. That's really all that whole paragraph is saying. And we're not the other thing that first whole section is making clear, which I think is important, is we're not creating any rights in this code. So we're not waiving any rights, and we're not creating any additional rights, which I think is probably, well, my opinion is that's where we should be. We don't want to create additional rights, but we don't want to waive our rights. But that's really all that's saying.
But taken out of context, this is hard when you're trying to read it.
Okay.
Because to me, the critical phrase is acting within the scope of their employment.
So let me tell you a little story that this, the first thing I thought of is we had a septic inspector here at the county years and years and years ago. And he went out and the person installing the septic system put in the wrong pipe. And so rather than just writing it up that you need to change the pipe, the inspector took it upon himself to go out and jump on the pipe and break the pipe to try to prove a point. I've had this experience happen to me with a plumbing inspector that didn't like my gauge because my installer had bent it, and so he literally takes a wrench and busts my gauge. So now not only do I have a busted gauge, I'm responsible for cleaning up all the glass that he spread all over my customer's property. So, you know, we need to, you know, the statement of, you know, the county won't be held responsible for any damage done during an inspection resulting from an inspection could be construed improperly.
Okay. So is the board, really, what I already said was, I think that the key to this particular paragraph is those two things. That by enactment of this code, that we're not creating any rights that don't exist, and we're not waiving any rights that exist.
And I think we accomplished that with that last sentence of that.
Well, I'd like to have just at least one or two sentences, at least one sentence about not creating any additional rights. So I'm happy to rework that.
Okay.
If that's.
Could you?
Sure. Sure.
And put it in the simple language you just gave to.
Like bullet points. I don't know if that was bullet points, but I have bullet points. Sure thing.
Okay.
All right. What else does this do? Really, subsection E really talks about, is really statutorily, it mimics a lot of the statutory language about unlawful subdivisions, same with unlawful conveyance.
And so on that, because some questions have come up about
Mhm.
the amounts,
Mhm.
that's in statute, right?
I believe it is, yeah, I think that's exactly how the statute reads on those ones, so.
The $1,000, $500.
Yeah, yeah, that's right out of the statute. Those amounts. And again, then you get down to subsection, or section F, unlawful acts in relation to zoning. Again, this
So
is
let's,
just,
before we get to F, let's look at, 2A.
okay,
Should we add a, less than 35 acres in that section?
I don't think that's necessary because less, what do you mean less
I
than
mean, if it's-
35 acres?
So if it's greater than, because it says they can't transfer until they have a final plat.
Right. So,
If it's an exempt subdivision, that's,
well, I don't think that's necessary, and here's why.
okay?
If somebody is dividing land, and every piece is over 35 acres, that is not a subdivision.
It says unless exempt.
And where does it say that? Am I looking at an older version?
If we,
I don't see that.
Well, that's unlawful conveyance.
Yeah, I'm under, I'm sorry, are you looking at unlawful conveyance or unlawful
Yes,
subdivision?
Unlawful conveyance.
Okay.
So, well, okay, so reference, just right
So
above that,
that's-
one A talks about exempt, division of land. Okay? And that's at 3828, 10110. That's a definitional statute of what a subdivision is. So then I would carry that thought process down to 2A, and it's using the term any subdivider or agent of subdivider. Well, those are not subdivisions. And so I don't think that this applies at all to those non-subdivisions.
Okay.
Does that make sense?
No, it makes sense, I just, I flagged it because it just
Well,
rang out to me that maybe that it needed some clarification.
And
I would not
also
have
under the
known that.
unlawful conveyance, it talks about for subdivided land has been approved by the Board of County Commissioners, and obviously a 35 plus would not come to you.
Okay.
So I would not have known that had you not said that,
What's that?
that it does not apply to 35 acres.
Well, I think we should really be careful about terminology,
Yeah.
all of us,
Yeah.
in this entire process. Unless I slip up, you won't hear me refer to a division of land with everything over 35 acres as a subdivision. I think we should, and my encouragement of everyone is don't use that term, because statutorily, that's not what it is. It is a division of land.
Yeah, but we're not all attorneys.
Well, I know, but the statute is the statute, we have to work with that. And so I'm gonna continue to encourage, every time we're talking about that division of land, if everything is over 35 acres, don't use this term subdivision, use division of land, use some other term. And that specifically, look, the statute says, no division of land constituting a subdivision. So there's some division of land.
Okay, so under administrative remedies, could you add a sentence or two indicating that,
Just clearing it up.
just clearing it up?
Under it, I'm sorry, you're
Or
down.
somewhere within here that it's easy to find, and is, because I would not have known that, John. That a 70 acres split to 235s is not a subdivision.
I can sure expound on the statutory reference, because that statutory reference, that's what that is, that 3028-101. I'm happy to expound on that in E1A, under unlawful subdivision.
Somewhere in there, so it's easy to spot and understood.
Maybe parenthetical or something.
If he expounds on that, that'll be in 2 more pages. It's on there.
Mike, I don't do that.
We're trying to reduce pages here, John.
I'll just reference something else. that
Okay,
has-
thank you. Okay.
No, that's really pretty sure, that's straightforward.
Something in the unlawful conveyance section. Just fix it to free up the dumb minds like mine.
Carl, could you possibly clarify that number 4? Because I think we're getting some conflicting info between the two of you guys about that number 4 above that you guys just covered, the fines.
The civil infraction? Is that what you're referring to?
The civil infraction and whether that goes to and is voted on by the Board of County Commissioners and goes before a judge before that's issued, or if it's.
Well, if I can, I'm gonna look to the chair, sorry, the public.
Apology.
Hey. Mr. Chair, I'll just note, I've been having meetings with the coalition, with Eli and Adam and Doreen, and we, as I mentioned to them, we have standard operating procedures for code compliance beyond what's in the code here. And so there's more detail in the SOPs than there are in this land use code. And we've set up a procedure where enforcement actions go, there's a committee, that's a technical committee of staff, and then also before going to the higher level of enforcement, it comes to your board, so that you're aware of it before, we go and get a warrant or, issue a summons complaint or whatever that might be. There are steps, not just the code compliance officer going out and writing a citation. And at that point, then that citation also is able to go to the court, and the court will decide whether or not to validate that citation or not.
Okay. And so the question is, should we put that information in this land use code? Is that correct?
I think that was one of the questions that have come up, yes.
Will that help people understand the process better?
It would provide more detail to the process, but then, an SOP is something that we're operating under.
And it could change?
And it could change, yes.
Before we change land use code again?
Right.
Do you understand the question, commissioners? I can see the need to put more clarity in how that works. It'll also take some of the fear out of it. So that if I receive a complaint or a letter from a code compliance officer, this is what it means.
You could reference, you could authorize the director to create, standard operating procedures, whatever they want to call them, and that could be a separate document. That could be available online or something like that. And that's an option, something like that.
Are the SOPs available for the public to see?
I think we talked about putting those online. Have we got those up yet?
I mean, not all of them, but the code compliance one is online.
Now it is, yes. It wasn't before, but it is now.
Well, and I appreciate that you have in here that these fines were set by statute, not the Board of County Commissioners or anybody else. And it's my goal that before we fine anybody or issue any type of legal document against the individuals, try to work with them as much as we can, as much as we legally can before it comes to a legal matter. And we've had some good luck in the past with our code compliance officer doing that, working with the people before fining, and there have, as far as I know, haven't been any fines levied,
That's correct.
anybody. And, I mean, that's my goal, keep it that way if we possibly can.
At this juncture, we've not even issued a notice of violation, an actual citation. We've issued advisory notices, which are not, they're not citations, they're advisory, informal. We haven't got to the formal part of the process yet since adopting the land use code.
This reminds me of a James Madison quote. If men were angels, there would be no need for government. He also says that if government were angels, there would be no need for a constitution, so.
And from the fine perspective, as Commissioner Lane was mentioning, there are some that established by statute, like we were talking about. We do have a resolution with a fine schedule for junk and rubbish, but just junk and rubbish, and it's a graduated fine schedule for that purpose. And so the first offense is $100, and then to go all the way through that and it's still not resolved, then the next one is $300, and it graduates up from there.
Would you guys like to see a copy of this SOP for you? Form an opinion?
The SOP can also reflect whatever management wants it to reflect. So, you know, through the county administrator, through the board saying, hey, this is what we would like to see outside of this document. You know, that can be tweaked, and I think the board is aware that, you know, there is a review process. Carl just mentioned that within staff and that sort of thing before any, I mean, they haven't even got there, but that's, process is built.
Could you distribute that SOP to the three of us? Print it, please.
This issue, that obviously, I mean, this has been one of the contentious issues with the folks. I mean, a lot of phone conversations, a lot of in-person conversations regarding this issue. And I'm still trying to know the right path forward, because ultimately, you know, there's still problems that have to be fixed. And these problems don't fix themselves sometimes unless there's a, you know, we can offer as much care as we want, but eventually the stick's gonna come out.
So, I mean, it's important to remember that we're talking about civil infractions. That's all we're talking about. That is the lowest, least pushy enforcement mechanism at all. And so to leave that at the staff level with review of a committee might be a reasonable approach. All the other approaches, all the other remedies that are referred to in 1, 2, and 3 have to be directed by the Board of County Commissioners. That's what this is, how this is built.
And the other part of this, I mean, this is land use code. This isn't junk rubbish.
Correct.
You know, and that's where you gotta put it in that other mindset of, you know, exactly where, when, and how will this be utilized within the land use code. So it's, you know, junk rubbish is pretty specific. I mean, it's, you know, you've got a pretty straightforward path on junk rubbish and how you need to proceed. The land use code, it gets a little stickier in there, because, you know, we've got a whole chapter 2 of, you know, suitable uses and limitations and conditions and just, like I said, it just opens up a little bit wider path.
I think bottom line is that the decision before the board is, in regard to civil infractions, are you comfortable leaving it with the code enforcement officer with SOPs that run through a committee of staff and that sort of thing, and attorney's office? Or do you want to see every single one of those? before the board, That's really, I think, where you're at.
And I'd like to read through the most recent edition.
Of the SOP.
Could you talk to us about section 4A on complaints?
Section
4A?
That's one that includes recommended edits. Actually,
It's page 198.
right at the bottom of page 198. There was a sentence there about the complaint shall be filed in the appropriate Delta County office. Delta County officials and employees, including the code compliance officers, authorized to investigate and pursue violations in the regular course of their duties, that is, without a complaint being filed. What this section is getting to is anybody can file a complaint. Before in the junk rubbish code, it had to be the complaint had to be signed and filed specifically, I think, in the planning department. This is there are other ways to file complaints. It doesn't have to be a signed form. People call and will register a complaint. People were concerned about signing complaints because of retaliation. We don't allow it to be anonymous. There has to be a person behind the complaint. But other than that, the complaint can be made by anybody. The part that was taken out was there was some conversation about whether or not wanted to be able to say we want to address this area, or something like that, which would then become proactive versus reactive enforcement. And there was some concern about having that in here at this time.
Questions on that, commissioners? Yeah, it's a change that we should be aware of.
Well, hold on, I don't know what that is, but I'm not gonna recommend that you strike the language that is stricken there. I think it's important to retain the ability to investigate violations, and regardless of who that is, to strike that language, if I'm reading it right, well, I don't know what that does, Carl. That's just taking out like half of that phrase, so. We can't remove the ability of county staff to see a violation and be able to act on it. I don't know, that's the important part, is we need to be able to, code enforcement, code compliance needs to be able to do their job. Again, then it becomes operating procedures and management directive beyond that. So I don't know, what are we, Carl, what are we trying to,
But
what are
also,
we accomplishing
John,
here?
I'm gonna push back on you a little bit. Because when we developed the policy, with civil infractions and everything, that we were going to be a reactive, not proactive process in this. Where I will agree with you is that, in terms of life safety issues, somebody blocking somebody blocks the side of their driveway and messes with obstruction of sight, we're talking life safety. These are things that staff should be able to address and take care of, because these are life safety issues. What we don't want is, the proactive enforcement of the code enforcement officer driving around looking for problems. I think that's the concept here, and that was when we developed the policy. We wanted to make sure that wasn't the road we were heading down.
We did want them to be able to address sewer though.
Well, and that, once again, that's a life safety issue. If somebody's dumping raw sewage on the ground,
Health safety.
that's a health safety issue there that should be able to be addressed.
it's almost never, I mean, I'll just speak from my experience. It almost always causes more problems to have a strictly complaint-driven process. It's a little counterintuitive, but it almost always ends up with neighbors fighting when you have a strictly complaint-driven process. Whereas you can have consistency when a management and procedural and policy-driven approach can be had towards a certain thing. Because if you have neighbors that are just complaining against each other, there's a sense that you're obliged to respond to that. And this has been working with Brad Lewis over a decade on these sorts of things. And you end up spending a lot of your time in the complaint-driven in the enforcement process on things that really don't rise to much of a level. And the things that do rise to level never get a complaint. And so I think it's very inefficient. So.
How do we manage the perception for the code compliance officer that they're out there to get somebody?
Whose perception about who?
Anybody's perception, if that code compliance officer steps on my property, all they're gonna do is write paper.
I think the protections that you have are exactly what we've already talked about. It is operating procedures and a review committee. And education, I mean, that's all you can do.
Once you get that perception out there they're out there to get you, it's hard to pull that back. And I don't want to see our code compliance officer in that position, because it also limits their ability to do their work.
Agreed.
And again, part of this is personal driven. We gotta have the right people in the right positions.
What you did talk about in some of the previous meetings was if Road and Bridge saw something, how would they bring that forward? So that had been discussed at previous meetings.
But anybody can.
Right, that was a topic of conversation.
So yeah, think of it that way. Anybody can complain, but we need, are we restricting county staff from
No.
complaining? Okay, well, that's all I'm saying, is I would not recommend a strictly complaint-driven neighbor, because that never works well. That's all I'm saying. As long as anybody can.
County staff are also citizens of the county. Thoughts? Again, there's no perfect solution to this.
Well, let's get the public input on that. And it's hard to, when your county attorney is telling you we shouldn't strike this, to strike it.
Well, like, I'm looking at what's stricken, and I don't know really, I mean, what does that accomplish? I think you should file it, I mean, it's just, okay, that's administrative, this is where you file it. And then Delta County officials and employees, including the code compliance officers, authorized to investigate. What does that really say beyond what we've already said? Or what does removal, what does that accomplish? What does it do to strike that language?
It's that perceptional, to me, that's perception. Yeah, that's.
Okay.
And I may be wrong. I'm not saying I'm right.
Okay. If it's strictly perceptional, it's, I think maybe substantively, I don't know that it's changing a whole lot in that paragraph.
know we've received some written comments and emails on this particular topic. This would be another one to flag, to see what the public has actually given us on this. How do they view it?
I think there's some room for some language in there, you know, regarding staff and life safety and those types of things. Because, you know, there's still bad situations out there that need to be taken care of.
Will we revisit this again after we get some more public comments?
There was,
Laying awake at night thinking about this.
I won't. I do lay awake at night thinking about things. This won't be one. I mean, these are prudential decisions, right? What does the board want? How much decision does the board want on this, and how much not? And where this lies with staff, with management, with operating procedures, with committees, where does the board want these decisions to lie? That's all this is.
That's why I want to see the SOPs. Anything else in chapter 13?
yeah, there was one we skipped over to come here, but under condition compliance, failure to comply. There was concern with this section relating to site plan reviews or permitted uses as they were referred to. We don't apply conditions, those are ministerial actions, the site plan review, so this was just to clarify,
And where are you at? Once again,
page
line
top of
you got?
198, section 2B, failure to comply with conditions of approval. And so the discretionary permits where conditions apply would be the limited use and the conditional use. Those are your permits. Whereas before it just said project, which some were interpreting to include site plan reviews. That was not the intent.
Okay, so the one right before that, number A, monitoring.
Yes.
I would like some language that's saying that the inspections can only be done until completion of the project. And that inspection period can't last for eternity.
What if there's a condition that applies ongoing?
Then that's covered under our,
I mean, many conditions, once they're cleared, they are cleared, but occasionally there can be conditions that are ongoing.
then we need to be clear in our language, whether it's part of if we have a development plan that requires continued investigation, or whether it's a project that once its application is complete and done, the inspection, right for inspection is done at that point.
Would an irrigation plan be an ongoing compliance issue?
It could. I mean, if it was something about, yeah, I mean, how it works, and then at some point later, it wasn't working that way.
Well, that's a whole. That's a whole.
Yeah, I know we don't
separate
get
issue.
into, I was just, so typically with the irrigation, all we do is ask them for an irrigation plan, and then that irrigation plan is part of the project. So irrigation, we don't go out and enforce
So,
the irrigation.
So that, Mike brings up an excellent point though, because at that point in time, if that thing fails, then that's a civil issue between the applicant and the designer or the installer.
Right, but we had a concrete batch plant that had a business operation plan that says we're gonna operate between 5 AM and 5 PM. If they open at 4:30, they're in violation of those conditions, and that's in perpetuity, that's for as long as that business is in operation. It doesn't, you don't just check it off and say, okay, you met it today, and we're not enforcing it anymore.
So that takes me back to my point, where we need to be more specific on this.
We've had approval, I mean, I'm thinking about an old specific development approval, but, which, similar concept, but, that restricted the height of particular buildings or something like that. Well, that's gonna be, that's not gonna go away, a height restriction or something like that, so. So you, Commissioner Supis, you'd like to see some language about, compliance with permits or conditions, but something about ongoing conditions or something like
Right.
that.
The timing of the
There's
compliance.
there's gotta be some way to clean this up, because there's a lot of these applications that come through that once that application's complete, there's no reason for it to be inspected again. And this basically states that we can come inspect at any time. That's what I'm asking.
Yeah, there's different types of conditions. There's those you check the box and they're done, and others that
Right.
apply,
Run with the land.
run with the land, with the permit.
Correct. Right, just some clarification.
Okay.
Just for clarification, it was the same with specific development, we have the very same conversations, so this isn't anything new.
Look at grade specific
Yeah.
Something good out of that. Anything else for chapter 13, gentlemen? Chapter 14 is definitions, acronyms, so forth.
Yes.
Is there anything you wanted to point out to us here?
Yes, for accessory dwelling unit, I mentioned earlier, we added what the dwelling unit includes: mobile homes, modular homes, tiny homes, recreational vehicles, when connected to permanent infrastructure, yurts, cabins, accessory dwelling units, et cetera. So we took that from the definition of dwelling unit and brought it forward here, so rather than having to flip that definition, it's in both places now.
I noticed some OWTS cleanup also.
Yeah, OWTS cleanup, and then, single-family detached residence, another OWTS cleanup. And then the appendices similar to what was after the table of contents. Deleting the design installation guidelines for underground irrigation water conveyance, and then removing from the appendices for the land use code, the junk rubbish ordinance, and the personal use cannabis ordinance.
Did you guys catch all that?
Yeah.
Any questions on chapter 14, anything you want to bring forward?
On page 218, on the parks passive recreation, I'm not familiar with the term tot lot. Is that like just a baby play area?
Yeah, it would just, basically it would have play equipment for younger children, slides, swings.
Everyone, we've covered quite a bit today. I think we've put some more clarity out there, plus we have some real definitive areas we're looking for good input on. One thing I would like to understand and do in this room, we have people here, is what the schedule looks like tomorrow at 4:30. We've got BoCC special meeting. We want to hear from the public on this. We hope we get some good input on those areas where we really need some good definition. Some good thoughts. What's after that?
Well,
We had a 30-day.
well, Commissioners, I think, so procedurally, we need to be clear kind of where the board is, because it's getting a little confusing, I guess.
It is.
So at this point, earlier, the planning commission certified a copy, which we referred to as the PC certified copy from November 16th, 2022. On December 7th, the Board of County Commissioners referred a couple of items, and I should say submitted a couple items back to the PC for consideration and report back. That was the lot size variance and some of the recycling on regarding solar and some of those things. And now the PC has reported back on those. So effectively, what you're actually set for tomorrow is the public hearing on those matters, really those matters, of the report back on the PC certified copy. That's where you're at. Clearly, in this particular work session, the board is considering, I'll just say considering, some additional changes, okay? So if in fact the board does not adopt tomorrow the PC certified copy from November 16th along with the, either in itself or along with the PC's report, if the board chooses not to do that tomorrow, then I think that procedurally the best way to proceed would be, if the board is going to come up with probably not tomorrow, because obviously there's going to be feedback and some of these changes and that sort of thing. But when the board has a copy, and I would encourage a complete word for word, this is what the board would like, then that would be submitted back to the PC, and the PC given 30 days to review that. Statutorily, that's what it asked for. And then the PC would report back on that. And then I think the board would have another public hearing, and then that would be before the board to adopt or whatever you want to do at that point. Does that make sense?
Mm-hmm.
I know there's a lot of back and forth here, but because the board is considering, well, these are some significant changes that the board has talked about today. This is a work study, it is a work session, so, but that does need to go back to the PC and then the PC report back on that. I'm going to encourage the board, before you send it to the PC, to have a word for word exact, this is what they like, rather than, hey, work on paragraph E on page 292 or whatever it is. Just so that it's clean and everyone can see what exactly language we're talking about. So, does that answer your question, Chair?
I think if we choose to go in that direction, I think the BoCC would have that.
Okay. So, so then to kind of recircle to that, once the board has that, this board, if you submit that land use code, then the PC has 30 days to respond. And you can set those deadlines out. There's notice, there's publication, and then you have a public hearing and that sort of thing.
So as of today, there'll be at least one more, there'll be a public hearing tomorrow, potentially a second.
Yes, unless the board just went forward with what you have in front of it, not the stuff we've talked about today.
Correct.
But I think you need another public hearing. I think that's best practice. On the final version.
Yeah.
Now, on your calendar, I have a land use code meeting Wednesday morning, so that is no longer valid.
You had put that in place for review of what you hear tomorrow night.
And we still want that.
It's up to you guys, but that's what you had put in place.
I do, because that's the start of the concatenating of the comments. If you still have time available Friday morning at 9.
You bet.
Wednesday.
Wednesday morning.
Wednesday morning.
Excuse me, Wednesday morning. Mike, Don, anything else?
Answer on how to clear the spots behind my eyes, but it's all right.
Well, I appreciate the hard work the staff has put into this. And look forward to working on with you guys further. Having said, we'll adjourn at 2:14. Thank you, everybody, for attending.
Wendell, can I ask you a question? Because you said something in this meeting that you would like to hear comments from the public on these specific, how would you ascertain those comments on those specific issues?
You got 3 minutes tomorrow night, or you?
How would people know what to comment on if you're asking?
Sorry.
Everybody's interested.
So, sorry, Mr. Chairman, I should, tomorrow night, and this is, thank you for that question, because it prompts another comment that I was thinking here. There's this copy that Kate's been working on and Carl's been making notes. That's not what's been posted.
That's correct. That's a good point.
And so what's been posted, if Carl, correct me if I'm wrong, is the PC certified copy, only with the changes to for lot size and the recyclables.
Correct.
Okay, so the public don't have that. Do you want them, I mean, this is not really my place to say this, but I'm gonna say it just, do you want them to have that? This document with some notations or anything for tomorrow? Is that kind of what we're because you're not gonna get comments on something that people can't
That's
see.
right.
I'm gonna suggest that we give staff a chance to refine our conversation today, give us a chance to muddle through this just a little more. Maybe on Wednesday, we can make a few other adjustments, I don't know if that'll happen or not. And then we can, because once technically the old revision, the planning commission vision will be gone, then we can put out a draft revision of what we've discussed here today. And then they can review a red line draft revision of what we've discussed, and then we can take comments. I personally prefer the email comments. I find it's very helpful. I can put the email on one side with telling me what people think about section, chapter, verse, and I can look out on the other screen and point it out. To me, that's very helpful. So.
I would look at Carl, then Carl, is that something you think we might have available Wednesday?
Well, it would.
Well,
it
you mean
depends.
following your discussion Wednesday?
If this goes, if the board does not adopt tomorrow night. The piece,
There
correct
will
piece.
there will be a draft. The final draft would not be ready Wednesday because you don't know what you will hear tomorrow.
True.
Right, and that's what I'm saying, that Wednesday we can have a discussion, discuss further what we've discussed today, and then hopefully we'll maybe have a draft ready that we can send out for everybody to look at. And then changes from there. But the other challenge of that is, we send out this draft, we need to then review that draft, and then we're gonna have to put out a kind of a final version that we have the public hearing on, and then it's 30 days from that point before the planning commission see that. So this isn't gonna be a quick process.
30 days till they report back.
Yeah, they have 30 days till they come back to you. They'll be able to
so
see it during that 30 days.
I thought we had to have it out for 30 days before the planning commission, okay.
No. They have 30 days to report back.
That's by statute.
That's something for a 30-day reprieve, so.
So in answer to the question, we don't know yet. Depends on how many substantive comments we get tomorrow night and what it will take to incorporate them. But please continue to work with us. Thank you.
Happy to chat further.
Yes. Yeah.
This all check.
Lori, that's right.
You work on retake out of that? Because that's gonna.
Okay. Okay, and I think maybe I answered a few things.
Well, I think we were gonna talk, I'm just following.
I'll
We just
try.
never got-
I'll try.
No, it's okay, it's okay, because we just got.
I don't.
I know.
Try to figure it out.
It's a lot.
It's
Comments?
figure outable at this point, that's for sure.
It's gonna be really.
It's in process.
It is in process.
Multiple drafts going.
I understand that.
But, you know, it's really also very educational.
I know, but I thought maybe if we needed to, that means we're gonna want to have some.
That's great rule for one.
All right, well, I'm sorry if I didn't pick up on that.
Now I realize there's.
Saying is that somebody else will do it too.
So.
Right, and then since you brought it up there, it's really easy to see that.
When the finish, I should switch down their volunteers.
Well,
You can get your.
No, I don't think you can. I don't know if you've tried doing this. It's really not a lot of time.
I just like to see something in there about the.
all right, yeah, so if you'll only work on that one